rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, hear, all persons having business in the appellate court are here. Your attendance shall be heard. Please be seated.
Good afternoon, everyone. Welcome to the Appellate Division, First Department, oral arguments for today, October 29. So please, as you are aware, only request the time that you actually need in order to get out the salient points of your arguments. We are fully familiar with your briefs, with the record. If we have any additional questions after the red light goes off, we will certainly ask those questions. People v. Julio Murillo. That matter is submitted. VB Soho v. Broome Property. Do you have a cross-appeal appellant? No. 5 and 5. Matter of AB Children. That matter is submitted. Wilmington Trust v. Farkas. Are you on this case, or are you just stretching your legs? Oh, okay. 5 and 5. West Park Presbyterian versus Center at West Park. Oh, there you go. 5 and 2 and 5. Bonacore versus Ramadran.
10 minutes.
So you guys are not requesting any rebuttal, so you're not going to get any rebuttal, just so we're clear, okay? 5 and 5. People v. Robert Moore. That matter is submitted. Sakali versus Hines, 1045 Avenue of the Americas. Respondent called you earlier today and stated? And you're requesting? Good. 4 minutes. DPI Imports versus Q4 Designs. That matter is submitted. 585 Gerard Acquisition versus GAL Manufacturing.
Joseph Newton for appellant. We request 10 and then 3 for rebuttal.
Respondent?
Richard Slack for GAL Manufacturing and Group 585. And respondents would like 9 minutes.
Wait about for respondent will need capital 5 minutes.
6 and 2, 6 and 5. Matter of Balbrena.
Sean Egan for the appellant. 4 and 1, please.
414. 4 and 1, 4 and 4, excuse me. Lewis v. Thomas. That matter is submitted. Umami Labs versus Ersman.
Joseph Cruz on behalf of the appellant, Alexander Golubitsky, 4 and 2.
4 and 2 and 3. Could you whisper a little louder? I can't hear you. Yeah, okay, thank you. Frommel v. West 2005, Hines West.
Appellant 5 minutes, 1 for rebuttal.
There's no respondent. Did you wish to submit or you still wish to argue? Thank you. That matter is submitted. People v. Sean Pessoa. 313. Gopart versus National Income Life Insurance. That matter is submitted. Milgrew versus the Board of Education. 525. Hicks versus the City of Syracuse. That matter is not submitted. There's no respondent. Did you still wish to argue? 4 minutes. Thank you. First matter for argument, People v. Julio Murillo. Did I do something?
Do you have to call the artist for me?
No.
Just curious.
Murillo was submitted. Apologies. VB Soho versus Broome Property. Yes, whenever you're ready.
May it please the court, Rip Gajar, Colbert Law LLC for the appellant, BB Soho LLC. Appellant commenced this action seeking redress for an improperly constructed condominium unit, one in which the parties agreed would have the kitchen specifically designed for and containing an integrated wine cooler. It is undisputed that the offering plan binding the parties makes reference to two specific wine coolers that would be provided to appellant, both of which are under-the-counter integrated units.
Counsel, the drawing of the unit, in particular, the drawing of the kitchen of the unit, didn't show the presence of a wine cooler in it, even though it showed the other appliances. Isn't that correct?
The drawing, I'm not certain about the drawing, but certainly in the offering plan, it did make reference to two
No,
specific.
I'm talking about the drawing didn't show the other appliances in the kitchen, but didn't show the wine cooler in the drawing of the units.
I believe,
layout.
yes, I believe that is correct, but I think the agreement between the parties based on the offering plan,
Right, but the drawing was in the offering plan.
And
so
the
it's-
offering plan only makes reference to wine coolers, but your argument is that the specific wine coolers listed, there were two of them, those are integrated wine coolers. That's how
Those
we
are-
get there?
yes, that is correct. That is our argument, that by offering those two specific types of wine coolers, it would be equivalent to it. Now, there is
Now,
language.
they could have been integrated under a different counter, not in the kitchen, right?
That was not anticipated. I mean, I guess.
Well, I don't know what was anticipated. Is there anywhere in the offering plan that said that it was going to be an integrated wine cooler located in the kitchen?
It seems like that would be just by the layout of
doesn't
it.
say
No,
that.
it doesn't, but it certainly wasn't going to be in a closet, because that's not under
Could be in a
counter.
guest room.
Where there are counters, there would have to be counters there, because that's the wine coolers, the models were specific to that, were specifically integrated to that. Now, the offering plan does allow for substitutions, equal or better quality appliance, and we feel that the interpretation and the application of that language is where the lower court erred.
The interpretation and application of what language?
The language of better or equal to the ones that were.
How do we get to the kitchen, though? How does that language get us into the kitchen in terms of an integrated wine cooler in the kitchen?
It does make reference to an appliance. Appliances generally belong in the kitchen.
Are there not instances in terms of apartments where there are integrated wine coolers in rooms other than the kitchen?
Yes, yes. The layout of this apartment would make it, that would be very awkward.
I'm sorry?
That would be very awkward for this apartment. It's not a huge apartment. The apartment has counter space in the kitchen.
No, I understand that. What we're trying to get at is where specifically in the offering plan is it stated that this integrated wine cooler is going to be in the kitchen and that it has to be in the kitchen?
The models of the wine cooler are kitchen models almost.
Does that preclude their being integrated in other rooms of the apartment?
In this instance, yes, because I don't believe there's counter space in any part of the house.
But the models, these models in and of themselves are not such that they have to be in the kitchen. Is that correct?
That's correct. But in this instance, they have to be integrated and under the counter somewhere. And integrated and under the counter would obviously be in the kitchen.
But I think you mentioned previously that you need a counter.
Mm-hmm.
So you can have a counter in a guest room, you can have a counter in another room, right?
Or in
There
the
isn't any.
laundry area.
Or in the laundry area, right?
This apartment doesn't have that.
But I understand that. There was a walkthrough at some point in time, was there not?
There was, and there was an as-is statement. And again, the writing of the as-is statement that my colleague here relies on quite a bit makes reference to the wine coolers that were referenced in the offering plan, and again, integrated
But
and
it
under
says
counter.
only that the wine cooler will be delivered. It says nothing about integrated into the kitchen.
It made reference to the offering plan. It said the wine coolers as referenced in
So
the.
if I'm walking through my apartment that I've paid $3.6 million for, and I wanted an integrated wine cooler in the kitchen, and I don't see that, nor do I see any apparatus that would allow such, would it not be incumbent upon me to say something as opposed to checking off and stating as is, accepting it as is?
Accepting it, well, my client is not a architect or.
I don't think you have to be an architect. I think if you're paying $3.6 million and I want that integrated wine cooler in the kitchen, I could be paying $1 million and I want that integrated wine cooler in the kitchen, it better be in the kitchen. And I don't have to be an architect to see that it's not This is not, it's not in the kitchen.
Respectfully, that would be an issue of fact of whether that was a reasonable expectation.
I don't know respectfully whether that's an issue of fact or not, but thank you.
Thank you, Your Honor.
May it please the court, Robert Bernstein of Holland and Knight for the respondent, Broome Property Owner LLC.
Counsel, I'm wondering if the section that we're talking about here that mentions the wine cooler and then lists two specific wine coolers that are under-the-counter wine coolers, integration to be determined, they're under a section called kitchen fixtures and appliances. What are we to make of that?
Well, I don't think that there's anything that says that they'll be integrated into the kitchen. It's kitchen fixtures, and certainly the kitchen fixtures are in the kitchen. And the wine cooler was offered to be in the kitchen. That's something that the appellant has sort of elided over in his argument. One of the findings of the court below was that the plaintiff, the appellant, prevented the respondent, the defendant, from fulfilling a contractual obligation if it existed. So it is undisputed in the record that after closing, that the sponsor, the respondent, attempted to deliver the wine cooler, said, we will install this wine cooler under the counter in the kitchen if that's what you want. And the appellant said, no, I will not allow that.
Because there was an issue with the cutlery space and things of that nature?
Yes, there was a subjective affidavit of an architect who said, if you install it in the kitchen, there'll be insufficient cabinet space and cutlery space. And so what's also in the record is an affidavit from respondent's architect that says there would be no code violation, that it could certainly be done within code, and there was nothing to contradict that in the record. So what I'm really struggling to find is an area that the appellant has identified where there was an error by the court below. And I think on the facts, it's pretty clear that there was not. Even assuming there was an obligation to deliver this specific model wine cooler in the kitchen under the counter, assuming that arguendo, we offered to do that, and they said, no, we won't let you do that.
Is there anything in the offering plan that discusses a cutlery drawer or sufficient cabinetry in the kitchen?
There is not, and in fact, that was one of the findings of the court. I'm just reading from the decision here. Defendant offered to install a wine cooler into the existing kitchen or elsewhere in the unit, but plaintiff refused. Right? Plaintiff's own conduct prevented the defendant from fulfilling the obligations. And then it says also, plaintiff has not identified any specific provisions in the offering plan that require defendant to furnish an integrated wine cooler, sufficient cabinetry, or cutlery drawer. So none of those things are there. And Your Honor asked earlier about the floor plan. That's on page A0633 of the record, and you're absolutely correct. There is no indication that there would be a wine cooler in the kitchen on that floor plan. So we don't believe that the obligation existed to provide it in the kitchen. We offered to do it in the kitchen anyway. The appellant said, no, we won't allow you to fulfill the obligations. So of the findings of the court below, we just cannot identify anything where the court erred on the facts or on the law. The court below found that there's review of the offering plan and agreement show that nothing in those documents expressly states that the unit's kitchen shall include an integrated wine cooler, finding number one. Finding number two, likewise, the offering plan makes no mention of sufficient cabinetry and a cutlery drawer. And then the defendant has shown that the plaintiff prevented it from completing its contractual obligations. Those are the three findings on which the court based its decision to dismiss the breach of contract cause of action. And I don't think that any argument has been identified here that says there was error. And then as we also discussed, and I'll end with this, the appellant walked through the apartment, and as the court has already pointed out, saw the layout, saw the missing wine cooler, and signed a statement that says, as is. I take this apartment as is, this kitchen as is, subject to delivery of a wine cooler. Nothing in that allows for a
Well,
claim.
subject to delivery of the wine cooler, which is going to be integrated in the kitchen.
Well, if it said that, Your Honor, I would agree. Of course, it doesn't say that.
Well, it says mentioned in the offering plan, which brings us back to the beginning of this argument.
Well, but nothing in the offering plan says it will be in the kitchen. We think what the appellant is doing is referencing the Miele manual that's not part of the offering plan, saying that says integrated, doesn't say where, and is making a lot of assumptions to get there.
And this Miele integrated wine cooler can be placed in any room. It's not that it has to be in the kitchen, right?
That's
This model
correct.
is not such that it can only work in the kitchen, or it's only for a kitchen.
That's absolutely correct.
But it's a model that has to be integrated, right? It's not a standalone model.
It is not a standalone model, but it can certainly be put into the living room or elsewhere. I know that the appellant said during argument that there wasn't any other cabinetry or any other counters in the apartment. There's no evidence of that in the record.
So, out of curiosity, and maybe it's not in the record, with respect to wine coolers in other apartments, how was that handled?
Other apartments, as I understand it, and it's not in the record, had some installed in the kitchen, some installed in other elements of the apartment, and those options were offered to this
I
purchase.
thought the offering plan for the 2.5-bedroom apartments all had the wine coolers integrated in the kitchen.
No, the offering plan, the specific layout, and that's what I referred to as page A0633, showed the layout and did not show the wine cooler in this case.
Thank you.
Thank
Thank you
you.
both.
Thank you.
Wilmington Trust v. Farkas. Yes, you may proceed.
Good afternoon. May it please the court. I am Richard Franco on behalf of the appellants from Davidson Fink LLP.
So, counsel, a question preliminarily. You made an argument in terms of FAPA and in terms of its retroactivity and whether it's constitutional, unconstitutional, et cetera. Is there notice to the Attorney General?
Yes, Your Honor, we did serve the Attorney General. If it's not uploaded, then it will be.
When did you serve the Attorney General?
At the time that the appellant's brief was served.
And the Attorney General, to your knowledge, did not put in any
We have not
papers?
had anything from the Attorney General in response to that.
Thank you.
Just obviously, the court is familiar with FAPA, so I'm not going to belabor the arguments. In this case, the original action was filed in 2008, discontinued in 2012. As set forth in the brief, there was a bankruptcy wherein
Can you address the retroactivity argument?
the retroactivity argument, yes. So with regards to retroactivity, I guess first I would address the contract element of it, the contracts clause of the United States Constitution.
Before you get there, counsel, I'm just wondering because in your brief, you didn't make reference to certain cases that specifically dealt with retroactivity coming out of this department where we have already found that FAPA is in fact retroactive. Why would we go against our case law? And then a third department case just came out finding the same.
Yes, I am aware of the third department case, Your Honor.
Well, more so, you're aware of the first department case in which we are in.
Yeah, so I'm not going to belabor those points. I think that the bankruptcy in this case is a little bit of an element that does not necessarily exist in those other cases.
Do you think that's a sufficient reason for us to disregard our prior ruling?
I don't think that the bankruptcy case relies on the retroactivity of FAPA. If the bankruptcy argument in the brief is that the re-acknowledgement of the debt happened in 2010, therefore that this action would be timely whether FAPA is retroactive or not.
Does a check mark on a bankruptcy form qualify as re-acknowledging the debt?
It is signed statement of intention to pay. And
Was it an intention to pay or just an acknowledgement that the debt exists?
Well, because the debt would otherwise be dischargeable. So if she intends to.
Right, so on the bankruptcy petition, you have to acknowledge all debts. That doesn't necessarily mean an acknowledgement that you're going to pay. You have to acknowledge it for the purposes of the petition. And if you fail to do so, that could lead to the discharge of the petition.
Correct, but the intention is not just an intention that the debt is a debt. It's more than that. It is an intention as to the next steps in the bankruptcy and whether or not she intends to retain the property.
Is there any other proof? Is there anything else in the record to substantiate your contention that there was an intent?
Nothing that's not set forth in the brief, Your Honor.
I'm sorry?
Nothing that isn't already set forth in the brief.
You want to address the contract?
Well, just the lower court found that there's no right of the lender to deaccelerate the loan unilaterally.
What provision are you identifying?
I'm looking at paragraph 22B.
What provision of the contract do you say was violated?
Paragraph 22B5. The mortgage contract allows that when the borrower reinstates a loan, that the lender has the opportunity to, or otherwise, has the opportunity to return the loan as if it had never been accelerated.
So is that taking you back to the bankruptcy form?
No, that's a separate argument. I started off with the
Well,
contract.
how did that happen in this case? So you just pointed out a
The
provision.
lower court found that the contracts clause is not applicable because there's no right of the lender to deaccelerate the loan.
No, the provision that you just pointed to, how was that provision either
Because the-
violated or adhered to?
I'm sorry, can you ask me the question again?
The provision that you just referenced, you said applies. What facts do we have here that would apply to that provision you just mentioned?
That upon a reinstatement or any other bringing of the debt current to the lender's satisfaction.
And what's that specific action that did that? I think that, what is the specific, did you mention the borrower? What did the borrower do to?
In this case, the 2012 action, I'm sorry, this is the right of the lender I'm referring to.
Okay,
The 2012 action was voluntarily discontinued, and the loan was reinstated, and there was no foreclosure
and
action.
then, and how does FAPA play into that?
Because the contractual right is that when that loan is reinstated, the lender is able to then bring the loan to a state, in the words of the contract, as if it had never been accelerated.
How does FAPA play into that?
Because that is a contractual right that FAPA would interfere with if applied retroactively. When this was discontinued in 2012, FAPA wasn't, they had the contract that said they had the right to do something, and now a decade later.
Right, but I mean, the whole legislative history behind FAPA was to prevent these kind of unilateral actions by lenders. I mean, that was the purpose. It was when it specifically referenced the Engel case, it meant to, do away with exactly what you're talking about. So that's why I'm asking the question, how does FAPA play into that?
What I'm arguing is that it violates the contracts clause, and that it strips the lender of a contractual right.
Thank you.
Thank you.
Good afternoon, Your Honors. Yehuda Morgenstern on behalf of Respondent.
Counsel, is your adversary correct here that there's been an impairment, unconstitutional impairment of a contractual right that the lender
No,
has?
he's not correct because the contract, the mortgage in this action, standard mortgage only relates to my client's right to come current and pay up to deaccelerate loans.
So the provision says nothing about the rights of the lender? Is that what you're saying?
Yes. There's no right to, it's not a right that goes both ways. It's very specific to the borrower. It's not a right on the lender. So as a threshold matter, there's no right of to deaccelerate stated in the contract. So the whole contract clause is, the whole argument that there was a taking and that violates the constitutional contract clause goes nowhere, in my opinion. I just want to clarify one thing about the bankruptcy filing, which makes this case a little bit different from which potentially takes this case out of FAPA. The correct standard that was issued in this court is that it's not an acknowledgement of a debt. Acknowledgement of debt, whether that box that was checked off by my client in the bankruptcy proceeding is considered an acknowledgement of debt or not is not the issue. The issue is, was it an express promise to pay? It's a much higher standard. By secured property, like a mortgage foreclosure action, the only way for a borrower or defendant to reinstate the statute of limitations via an express promise to pay. Now on that bankruptcy checkoff, there's nothing that can be construed as an express promise to pay. At most, which counsel in their brief and an argument say it was an acknowledgement of a debt, but that's not the correct standard for resetting the statute of limitations. That being said, FAPA is clearly on point because there was a prior foreclosure action that was discontinued. In the voluntary discontinuance of that action, there's no mention of any deacceleration or anything. It was just a boilerplate discontinuance. And this action is presumptively time barred based on FAPA. And I would like to add that in the order appealed from, the court cited to Engel. Engel acknowledged that there was no, the law prior to Engel was not settled. There was no clear law as to the salient issue before the court as to whether voluntary discontinuance affects the statute of limitations. The law was not settled as to that. Engel, clearly, the Court of Appeals in Engel said, quote, there's no clear rule has emerged with respect to the issue raised here, meaning the issue before this court, whether a voluntary discontinuance constitutes a deacceleration. That was law in Engel in 2021, I believe. When they discontinued the action in 2012 or 2013. They didn't know what's going to happen in Angle 7, 8 years later. Like the court acknowledged and the order appealed from, they weren't clairvoyant, and there was no reliance that a voluntary discontinuance would consider a deacceleration. That being said, FAPA clearly applies, and the case is timed by statute of limitations.
You want to address the alleged due process violation?
So there was no vested right on behalf of appellant to discontinue an action based on voluntary discontinuance, to deaccelerate via voluntary discontinuance. Didn't exist. There's no court that said it had that right. There's no contract that said it had that right. Okay, I'll rest.
Thank you. Thank you both. West Park Presbyterian versus Center at West Park.
Good afternoon, Your Honor. Brian Isaac. I represent the defendant appellant here. Before I start my argument, I get into the consent issue, which I think is probably the main issue in the case. I just want to tell you what our position is and what my position isn't. We view the religious corporation law, the specific sections here, as being protective and being a shield for religious institutions to ensure that they're viable and to ensure that their congregants are not injured. And that's why you have the requirement that there be either court approval or attorney general approval for leases over 5 years. We do not view the religious corporation law as a sword that a religious corporation can use to actually undo a deal that was good at the time that it was done.
Part of the problem is whether the deal was good at the time, because what the principle of the religious corporation stated is that they weren't aware of the statute, and therefore they did not act essentially to protect their congregants, which as you described, I think correctly, is the purpose of the statute. So if they didn't act to protect their congregants, then it may not have been a good agreement at the time it was made, and why would we enforce it?
Because there's contrary evidence, Judge Gesmer, and this is a summary judgment motion, that they actually did know about the religious corporation
What
law.
contrary evidence is?
The evidence was McQueenie's testimony that he actually knew the affiants, that they were aware of the religious corporation law, and
How would he know what they are aware of in terms of the law?
no, but if they're
No, you're right.
I'm sorry, can I answer? Yeah, if they're aware of the fact that there's a religious corporation law and that it requires certain consents, okay, their assertion that we didn't know about it at all three of the affiants that the plaintiffs addressed all said we didn't know about that. We actually have, and we have no discovery, as you know, because that's also one of our claims, we actually have a website from 2017 which has the religious corporation law in it underlined.
Yeah, but wait a minute. It's a little more complicated than that. It's not a 10-year lease. It's a 5-year lease. So arguably it comports with the law, but of course the interpretation is correct because there's a renewal period. So I don't see that.
Well, again, your decision in the Soho case obviously says that even though we have a 5-year lease and then a 5-year renewal, it's a 10-year lease that triggers 12-5, 12-1, and 12-9. The fact of the matter is that on a summary judgment motion, if in fact they knew that there was this provision that required consent, and remember, if you read the reply affidavits of my adversary's witnesses, they don't say anything other than that my witnesses weren't telling the truth. So on a summary judgment motion, right after there was an answer, you have to accept what we say is true. And the problem with the argument that the defendants are making is it would allow a religious corporation to do precisely what they shouldn't be allowed to do here. Remember, my client isn't a developer. My client is a 501c3 company that is actually doing things that comport with what the church does. They're not looking to make money, they're looking to...
Counsel, had this been approved by the Attorney General's office, wouldn't that have been a matter of public record?
It might have been, it might not have been. The fact of the matter is that it's not, you have said in a case called Uloa against the city of New York that blaming your adversary for something that you didn't do is, quote, chutzpah. It's a Yiddish
Said
term.
that in the decision?
Huh? In the
Said that?
decision, in
We said-
Uloa.
We said chutzpah?
Chutzpah. Use the word chutzpah. That's why I did it. So blaming me for not checking a website where I have a representation, okay, that specifically says that everyone has full right and authority to enter into the lease is just reversing what ought to be happening.
There has to be protection of the congregants, and that's the issue. And that's why my colleague mentions the Attorney General. How do we know, how is it clear that the congregants are aware of what's going on?
Well, I'm not sure that the congregants are aware or aren't aware. I think.
Well, it says all provisions in this agreement shall be binding on both the church and the
Right.
binding on the church.
So my client might not know exactly what's going on here, but I'm an agent for them. So we're talking about agents, right? The people who submitted the affidavits, Ms. Flowers, who signed the actual contract, these are church members, these are church elders, these are church corporate officials. They're acting for the church. And the fact of the matter is that
Are they acting for the church or the presbytery, the larger organization? It's hard to see they're an agent of the presbytery.
may I-
Please respond.
Okay. So I actually wanted to talk about that because, look, I'm not a theologian, I'm not particularly religious, and I'm not going to pretend that I am. I made my own chart, okay? And I think that when you talk about the presbytery, I wasn't sure what the presbytery was at first. There's an overall agent that, from what I can see, that's called the Synod. Then you have the Presbytery of Brooklyn, and then you have the Session, and you have the Commission. But there's also a Presbytery USA, which is the overarching entity. And if you look at the affidavit of Reverend McQueenie at 528 and 232, he cites to what he calls the Constitution, which says, and I'm quoting, "A congregation shall not lease its real property used for purposes of worship or lease for more than 5 years or any of its other real property without the written permission of the presbytery transmitted through the session of the congregation." Flowers signed the agreement as the clerk of the session. So there's a real question here as to whether or not this was actually complied with. And I see my time is up. I'll deal with this in reply.
Good afternoon, Your Honor. Magda Cruz of Belkin, Burden Goldman on behalf of the respondent church. Your Honors, this case is actually quite simple, and this court has many, many precedents involving different transactions, both leases, as this case involves, as well as conveyances. It is incontrovertible here that the criteria of the Religious Corporation Law, Section 12, was not satisfied. And at the time of the lease execution,
Whose obligation was it to satisfy that condition?
the obligation was of the parties interested in effectuating this renewal clause.
So you're saying either party could have sought that?
Either party. I know that in the cases that I read of this department, as well as the second department, it was sometimes a joint application, sometimes it was a third party that wanted a conveyance to take effect. The point is, the Religious Corporation Law requires, it's not discretionary, for a court order or the Attorney General approval. And
And counsel, if the parties are representing that they have the authority to enter into such a lease, why can't that assume that the court order and the Attorney General part has been taken? Why can't the other side rely on that particular, that you have the authority, that you've done what you needed to do, you've crossed your I's, you've dotted your T's, let's go forward?
Right. The authority that was represented in the agreement, which, by the way, Your Honor, it was both sides made that representation, is simply that they are legitimate officers of their respective corporations and that they have the authority to sign. It does not at any point in this lease say that they have complied with the religious corporation law, and it does not say we will even prospectively apply for the required court order or attorney general approval. There are
Well,
cases.
one, does it have to say specifically that they are knowledgeable or as to the religious corporation law?
I would submit, yes, Your Honor.
And that's based on what?
I would submit based on the case law of this department. I believe that even in the case that is most relied upon by my adversary, Reed and Esposito versus, I believe the entity was St. Anthony's. I may be wrong on that. But Reed and Esposito, that involved a conveyance, and that, in fact, even had the language in the contract of sale that provided that the parties would apply for the court order or the attorney general consent. The point is, Your Honor, however, the critical point here is that those are necessary criteria, absent which it does not matter whether they knew or didn't know.
But wouldn't, if we permit this, if we rule favorably to your client, wouldn't it permit a religious corporation to not get approval of a lease and then decide it wasn't an advantageous agreement and say, oh, never mind, this is invalid because we never got the approvals we needed to get?
Your Honor, assuming that that hypothetical were the situation here, which it is not, the fact is that an agreement or a conveyance without the necessary prerequisites of the religious corporation law unsatisfied, it is a void agreement.
Counsel,
it cannot
can't
be
your
enforced.
adversary presume that all of the necessary conditions have been met by someone saying they have all the authority to act on a contract? And then, doesn't that place the burden then on your adversary to have to go and check to make sure that the religious corporation's law has been complied with?
It is a necessary criteria, Your Honor. So if my adversary, in this case the tenant, wanted to execute on this renewal option, they had also the obligation to ensure.
Why would it not be assumed that if I am signing on behalf of the church, right, that therefore I am aware of the religious corporation and I'm doing so according to that act?
Just, taking on that question, Your Honor, it doesn't matter. Even if they knew and they did not fulfill.
But why could they not? Why could that assumption not be made?
And relied upon.
Irrelevant.
And relied upon.
Because it is irrelevant, Your Honor. The fact of the matter is that even if they knew, or in this case, they did not know, it is the fact that the necessary order or attorney general approval was not obtained. That is what makes the agreement invalid and unenforceable. It doesn't matter. They may have if that were the case, they may have a claim for damages down the line. It does not reinstate the agreement.
Aren't you putting a very high burden on anyone who tries to sign a lease with a religious corporation?
I don't think it's a high burden, Your Honor. I think it's there in black and white. Anybody that executes an agreement with a religious corporation has to abide by both the religious corporation law and the not-for-profit law. And that simply is the nature of the entity in which you are transacting, because the religious corporation has special obligations to its congregates.
So the
and
burden
state
is on
protects them.
the burden is on either side, not
Yes.
just the religious corporation.
Yes, and I note on that point, Your Honor, that here you had the board chair of the tenant. Where is she in this voluminous record? Why didn't she put in an
Counsel, if the
affidavit?
burden is on either party, why have they not met their burden?
They have not met their burden because they are the ones that want the renewal option enforced, but they have not proved that the criteria for that option to be enforced has been performed here. And if those two criteria do not exist, the lease is invalid. It cannot be enforced. The lower court properly terminated the tenancy and properly awarded a judgment of possession to my client.
Thank you.
Thank you.
Your Honors, I'm sorry, maybe I'm dense, but I don't understand that argument, okay? If you come to this court and you tell this court that a case says something that it doesn't say, my experience has been the judges just don't listen to you because your word means something, okay? I just want to read to you what the clause says. It says, and by the way, this isn't my document, it's their document. Yes, it is. You're the one who drafted it. It's your document, and it gets construed against the drafter. The church and center.
Sir, isn't the issue whether or not there's compliance with the law, as opposed, I know you're focusing on the contract, but that's your strongest argument. But how do we grapple with that issue to say we make an exception now?
There's no exception. I'm not saying that I win the case, Judge Singh. All I'm saying is I don't lose summarily at this stage where I have
But
conflicting.
you're advocating for an exception. You're saying it's not void, it's voidable under certain circumstances.
Correct.
So
And
you are asking for an exception.
that's the law. It is voidable. My
Well,
position.
what case says that it's voidable as opposed to void?
The Rendy case says it's voidable, and 12-9 says it's voidable. If I have consent, let me make my position clear. My position is that I have consent from the church. I can go to 12-9 because I'm an interested party, and I can ask the court to then approve it retroactively non pro tonque.
But is it the specific church or is it the presbytery?
Well,
that has
that's
to
why,
consent?
Judge
And the
Pitbrook,
presbytery didn't consent.
that's why I read what our reverend said, because the way I look at it, and maybe I'm missing something, the highest legal document that you could have is a constitution, right? In American law, the Constitution is the highest, you can't go below it. What I read to you was from a book that we got, we didn't even get any discovery, which specifically says that the way this document was signed was congruent with the rules of the Presbyterian Church for America. Forget about Brooklyn, for America.
Well, you said it was the clerk of the sessions that
Yes,
signed it,
and
not the
that's-
sessions.
Says here, look at page 72, Your Honor. For the church, West Park Presbyterian Church, printed name, Marcia Flowers, title, Clerk of the Session. It almost mirrors what I read to you before. And again, I'm not saying I'm winning. I'm not saying it's a 240-1 labor law case. All I'm saying is I shouldn't lose summarily on this record. And I would specifically ask you, and I'll stop after this, to not accept the proposition that I somehow have an obligation to check a representation made by a religious institution to me that it had, quote, full power and authority to enter into this agreement and all of the stated terms and conditions.
Counsel, I think it's because you're dealing with a religious corporation that you have an obligation to make sure that the religious corporation law is complied with, because you're not dealing with just a regular entity. That's a difference.
Your Honor, it's a difference. I'm not going to tell you that it isn't, but I can tell you that I look for cases on that particular issue, and I can't find a single case, and I'm not a bad researcher, where someone has to check a representation made by someone else in a situation like this, where their very argument is that they didn't have the authority they said they had, or at least that it should be a summary dismissal of the case. I couldn't find it. Thanks for listening to me.
Bonacor versus Ravishaj.
Good afternoon, Your Honors. Joseph A. White for the estate. The error of the lower court in granting the re-argument and then dismissing results from the defense itself never, ever addressing the causation in the case. Okay? The causation in this case always was about the endocarditis. To some extent, the cellulitis, but the endocarditis.
So the initial bruise to the toe, based upon the stress test, that caused the decedent's ultimate demise?
It led to it, yes.
But how can that be? The records are really clear. There's some question as to when the toe healed. For example, on July 20th, well healed, and then in August, there's no question it's healed. So once it's healed, what's the link to causation?
The link to causation, Your Honor, is about the endocarditis itself. Okay. When the patient was brought back into the hospital by Dr. Vitti, okay, in March, okay, and it wasn't just a bruise. By the time he's there 10 days later, that's what we're seeing.
March, we're talking about after it's healed.
The endocarditis was never addressed by the defense. What the defense...
But where does your expert make the conclusion that the causation is that the injury to the toe enabled the endocarditis to fester and led to his death? I don't see anywhere where that is stated by your expert with a reasonable degree of medical certainty. It seems to me every time that your expert gets close to that issue, all of a sudden the reasonable degree of medical certainty disappears and it's more likely than not. So perhaps you could show me, I really am curious what you're relying on in the plaintiff's expert's report to get you there.
What plaintiff's expert said was on the basis of what Dr. Vitti said, who was a defendant at the time and the vascular surgeon who brought him in and who had been treating him for 8 or 9 years with no history of MSSA, right? Okay. When he brought him into the hospital in March to deal with what had been caused by the stress test, he had concerns about the cellulitis. He had concerns about having to give antibiotics, and he was concerned that since a pacemaker had been placed in during that February admission, that there could be an issue and a problem, okay, with the bacteria coming towards the pacemaker itself. All the more reason, he said, and it's quoted by the expert in his affirmation, all the more reason to get in there.
Counsel, could I just in terms of the bacteria heading towards his heart, was there anything in your expert's affidavit that indicated that the bacteria was slow moving, to contradict what the defendant's expert said about it?
Plaintiff's expert talked about the idea that you now have a permanently injured toe, okay? The scarring and the healing process that Dr. Vitti undertook in March, April, and May. Every time Dr. Vitti saw this patient, he had to, at least in his opinion, take out a scalpel and start removing necrotic and dead tissue.
But counsel, as the records reflect that as of May 13th, there was no longer any infection. So if there's no infection, where is the bacteria coming?
Your Honor, that goes back to the failure of the defense to address endocarditis. Endocarditis, okay, can be acute, it can be subacute, it can be chronic, okay? You can go to the American Heart Association website, you can go to any website, it's common knowledge.
Well, how does your expert, and I think this is what my colleagues are trying to find out from,
Yes.
how does your expert link that to the toe injury?
Because everybody at the hospital looked, he employed the differential diagnosis methodology. Everyone at the hospital, okay, both in March, as well as later on in July, as well as in September, kept saying 3 things. Everybody of the defendant's employee kept saying the same thing in the hospital records. 1, recurrent, okay? 1, recurrent, constant, recurrent, and a recurrent MSSA infection. Recurrent, if you look at the National Institute of Health site or any site.
What were the other 2 things?
The other 2 things, Your Honor, is that everyone looked for another portal of entry.
Right, and so that was the other thing, because there was reference by Vitti, and I think you're expert in terms of a portal of entry or something of that nature, but there was nothing further in the record as to exactly where that portal was or what the significance of such a portal would be.
Your Honor, I believe that Dr. Vitti himself, and we cited it page specific, I don't have that page specific in front of me.
Vitti used the phrase portal entry as with regard to the wound providing entry of bacteria for the original infection.
Yes.
But that was basically it. And also, as was stated by my colleague, at some point in time, the notation in the records is that the wound healed and the toe was infection-free.
Your Honor, a lot was made about that in the briefs, both sides, okay? There's only, on the plaintiff's side, the reason why it was debated is because you now have a different toe. And the further reason is, okay, even when they were talking about it in July, okay, that there was no evidence, that's when Mr. Bonacore was still on 6 weeks of IV antibiotics for the endocarditis. Okay? The endocarditis did not disappear.
So was there any testimony by the experts as to a direct correlation between the endometriosis and the toe? The injury, the initial injury to the toe?
Yes. Yes.
And where was that?
I'd have to find the specific paragraphs, but the paragraphs, I may be able to find them.
You can do it on rebuttal. Thank you.
May I?
On rebuttal, yeah, certainly. That's right. Okay. Yes, proceed.
Good afternoon, Your Honors. May it please the Court, Nicholas Tam from Schaub, Omni, Citron, and Spratt for the defendant respondents. The motion court's order should be affirmed. The plaintiff claims that the toe injury...
So I have a question.
Yes.
There's an entry in the records that as of, I think it was May, a date in May, that the toe injury was free of infection. And then there's an entry, I think it was July 20th, that it was well healed, H-E-A-L-E-D. And then there was an entry in August that it was completely healed. How are those, is there a difference among those three things, or are they the same?
It was those specific doctors' interpretation of what they saw.
But is there a difference? I mean, when the doctor said it's well healed and there's no infection, is that the same as completely healed, or is that something different?
They're all saying the same thing, that there was healing of the toe. The specific words...
Well healed and I think completely healed may mean two different things.
So in May 13th, Dr. Vitti's last visit, he writes, the right, quote, right great toe essentially healed. Underlying tissue shows wound almost completely healed, return in 2 to 3 months.
So at that point, it's not completely healed, right? Can we agree on that?
The words he uses are essentially healed and almost completely
Okay.
healed.
So it's not, okay.
It's not
He doesn't say, he doesn't use the words.
Okay, so when is it healed? When, according to the records, is it completely healed?
So on July 12th, when he comes back to the hospital with cough, fever, and chills, and a positive blood culture, there's indication that it was a well-healed ulcer, but you have to look at it in context of the other things that they said. No edema, no erythema, no discharge, no tenderness. There's also the infectious disease consult where he denied foot pain, ulcers, or swelling. There's also a patient history. Patient denies lower extremity edema and swelling. There's also a physical examination.
So just based upon what you're saying, since it was essentially completely healed in May, and then in July, all of these other things, which maybe indicates a little bit more healing, would it be safe to say that maybe this condition persisted at least until July?
Well, the way Dr. Pollack explains it is that MSSA is a rapidly advancing organism. As the court indicated, there was nothing in the record that said, plaintiff's expert said it was a slow-moving infection. In fact, he explained doubling time. And what that is the time it takes for one bacteria cell to replicate, one full life cycle, 1, 2, 4, 8, and so on, so forth. And what he said was, within 6 to 7 hours, you would have millions of bacteria. So there's no credence to this theory that it was a latent, hidden, or dormant asymptomatic infection over this period of 2 months between the last visit in May and the visit in July 13th. There were also other indications. The x-ray was negative. The gallium scan was negative. So what plaintiff has to do is bridge the gap, a significant gap between February and July.
Well, between May and July?
Well, so the injury occurred in February. He began his course of antibiotics for the first infection in March, and it was well healed by April. And then each subsequent visit, I believe there were 5 to Dr. Vitti, they were negative for any signs of infection, no fever or chills. And then
The first time they were negative for infection was May, right? May 13th.
no. So the first, no. There were no signs of infection. As soon as March 6th to the 11th, when he went to the hospital, the blood cultures were negative. The x-ray was negative. And then there were 5 follow-up visits that indicated the toe was clean, there was bloody drainage, granulation. All these things are positive signs of healing. And then in May 13th, Dr. Vitti indicates that it was essentially healed. But I just want to raise one more point.
So May 13th, it was essentially healed, since there was no infection dating back to March.
Those are the words that Dr. Vitti used, but taken in context, there were no signs of infection. But one last thing I'd like to address is this plaintiff's...
Was the healing process continuing from May into July, based on your review of the records?
No, that it was essentially healed at that point, and prior to that, for
But then,
2
if
months,
that's the case, don't words have meaning? Essentially healed, well healed, completely healed, or whatever it was in August? I mean, are you suggesting that there's no distinction between those terms?
Perhaps...
Doesn't it suggest that there was a period of time over which the toe healed?
Well, the doctor actually said to come back in 2 to 3 months, not because there was some type of underlying brewing infection.
When was that? That's May, right?
That's May 13th, correct. So just very briefly,
But-
plaintiff
and if
never
there
opposed
had- hold
Dr.
on.
Vitti's...
If there had been symptoms of infection between May and July, based upon your expert's opinion that it's such a rapidly advancing bacteria, there would have been maybe some notes in between there?
Some signs of infection, some signs of active infection.
Well,
Plaintiff's
on
failure
July 18th, excuse me, on July 18th, the decedent was in the hospital with fever and chills.
Yes.
So,
Due to
isn't
some
that a
other
connection?
reason, right? Due to something else.
That was never due. It was
we know
not due
that?
to the toe because it was already healed before that.
But do we know that from this record, that it's not related?
Well, they never did an autopsy in this case, and based upon Dr. Pollack's opinion, it was scientifically impossible. And plaintiff never opposed Dr. Vitti's summary judgment motion, so that's conceded. What's the significance of that? They initially claimed that Dr. Vitti failed to treat him from March to May. Those claims are abandoned, so this discussion is academic. And to quote the court, plaintiff acquiesced to Dr. Vitti's dismissal from this case, illustrating plaintiff's position that the decedent's right toe injury was properly treated and healed. And even if that's not a concession, there is ample evidence that there was no infection prior to his return to the hospital on July the 12th.
Thank you. Counsel, I have an additional question to you. So plaintiffs, the defendant's arguments are that this was withdraw. You're stating this was a slow-moving infection, right?
In part.
In part.
Yeah.
Their expert says that it couldn't have been slow-moving. It had to have been, if there was an infection, then the symptoms of the same would have manifested themselves almost immediately, and certainly not over a 5-month or a 3-month period of time.
That's the cleverness of the argument that the court accepted below. Any study,
Because it was a clever argument, because it was true.
any study of endocarditis at any point.
But what did you put in to controvert that?
We put in that there had been, that we put in that we had proof that as of March, the infection that was affecting the toe and causing the cellulitis, there are two entries in the hospital record. One says pacemaker, not functioning, possible infection. The other one says that's March 6th. And then March 7th, someone following on the heart and the pacemaker says myocardial infection, okay? Now, the reason why Dr. Vitti was sued and the reason why we stopped and didn't pursue is because he continues on each occasion to use a scalpel to open up the wound. He has to do that.
But
And
I'm
in
curious whether your theory is independent of whether the toe was healed.
Once the bacteria comes into the bloodstream and it's transient, it can, and it's well known and well said.
So your theory is that it came in through the toe before the toe was healed and then caused?
Oh, yeah, oh, absolutely, Your Honor.
And where does your expert say that? It's
what he
okay, I'll
talks-
look for it.
Yeah, and again, I did not see it in the record. He talks about the
He
portal
talks,
of entry,
yeah,
but
he
then
talks
there's
about
nothing-
it I'm sorry, Your Honor. He talks about it in terms of what's being written in the Montefiore record as constantly referring back to the diabetic ulcer on the foot, okay, at the time of the endocarditis in July.
But he doesn't talk
And
further
he talks
in terms
about
of
it
what
in
that
terms
means.
of recurrent infection, which is not his words, but the words of the doctors treating Mr. Bonacore at the Montefiore Hospital.
Thank you. Thank you both. Sicali versus Hines, 1045 Avenue. I'm sorry. Yes. Sicali versus Hines, 1045 Avenue in Americas.
Good afternoon. Allison Snyder with Barry McTiernan and Moore for the defendants' appellants. The one thing, there are a few points that I just wanted to clarify based upon my, when I was going over the briefs preparing for this. One issue that came up, or that the plaintiff raised, was this issue of installation, whether it was installed as part of the work or not as part of the work. That's
Whether it was what?
installed as part of the work, part of the project. There are certain instances where the object that fell had been installed, prior to the construction work that was being performed. It's really not a determinative factor.
You're talking about whether it was a permanent structure.
Right. So the buck frame, or I'm sorry, the door frame itself that they were working on.
Actually, since you're speaking of the door frame, I'm very confused, honestly, reading the deposition to try to understand what precisely happened here. What's the defendant's version?
Well, I have to say the plaintiff's description of what the circumstances were are confusing, but in any event, there was a door frame that was installed and was connected all the way through to the sheetrock, and after that, the raised floor was installed, and so basically, yes, there was a raised computer floor. It was about 4 inches off the ground, and so
But that does not play into the.
Well, it does to some extent because that's where. So if I can, so what happened was they ended up making an opening. They removed 4 of these floor tiles, and so in order to access the area, they were basically reverse engineering it. What they were doing was going back in and installing this metal frame. It was a one-piece metal frame, and so they were going back, and it acts as it's a little bit of a cushion in between, the floor itself, the sheetrock floor, and the header for the door. The door
Nothing
frame.
in the record refers to it as having a cushioning effect. I thought it was a stabilizing effect.
They were inserting it in the area, but that work had already been done.
What had already been done?
The plaintiff said that they had already installed this door buck. And
No, they had already installed the frame, but then he was told to install the door buck. That was a different entity that he was told to install into the frame that had already been put in.
And he did. He installed the door buck. It was just as they were leveling, they were testing it, they were leveling it out, and that's when the accident happened. So he had already installed the door buck.
So just going back to that, so he loosens the screws, right, on the top plate, and according to the testimony, he says, that the plaintiff, that the door came down, it shifted in my hand. What's the defendant's position, that the door moved or didn't move?
No, he was asked, if I could just refer the court's attention to the record at 226. He was asked specifically that, what came down? And he said the track. And so he's talking, when he refers to the top track, he's talking about a metal piece that's installed underneath the raised flooring. It's attached by studs. So that's what he's saying came off, was the top track. He doesn't know exactly what caused it to shift. And that's at 226. He says exactly that. And
when the track came off, then the door fell, or
he doesn't know exactly. He just said something shifted.
Was he asked?
Oh yes, this is at 227. He said so this top track collapsed, and he said it shifted down, and then it said how far down, and he said if there were 4 inches and my hand is 2 inches, it came all the way down. So he's talking about a metal piece, this top track, that was attached around the raised flooring, fell a distance of 2 inches. He just said it shifted down. Now,
But he also said at page 232 of the record that the whole door came down on his hand.
Well, that was before he was asked to clarify, right?
yes, but he was then asked later, and he said he was asked about the version of events that he gave in the C2, and he said, well, everything's connected. I didn't specify at the time that it was the top track. But
the C2 wasn't included in the record, right?
No, but he was questioned about the description. It was read into the record, and he was questioned about it. And he was asked later, well, why didn't you say it was a top track? And he said, well, everything's connected. So when he's talking about the whole door, I think it was just his shorthand description. But there's no dispute here that what fell was the top track, he said, and it shifted 2 inches.
I don't know where you get the no dispute about that when he said at one point the whole door came down.
Except that he was asked specifically what came down. He said the top track.
So my colleague asked you what the defendant's position was in terms of what occurred. So your position is that the top track came down?
Yes, and it's not just my position, it's his testimony that
based upon the record, your position is that the top track came down and not the actual door, because at some point in time he talks about the shifting of the door frame caused the door to fall.
Well, there's no door.
What do you mean that there's no door? Wasn't that what he was framing?
No, he was putting in this door buck, and he installed it, and he said that he was leveling it.
Right, but the door was already there, and he was putting the door buck in around the door.
Right, but that wasn't related. It's not related to the accident.
So the door buck is not attached to the accident, to the door.
No, it was installed. It was
so when it
literally
came
in between
down,
the studs.
was it not attached to the door, which thereby made the door come down on his hand and with the door buck?
Look, the plaintiff himself said it was the top track. He said something shifted. It's irrelevant though, because it's been installed. This was literally an object that was installed. But
it's not irrelevant because it makes a difference as to whether or not it's the top track or whether it's the actual door that then comes down on top of his hand, right?
Does it?
Yes, because if there's a reading of the record that says that an entire door fell on his hand, then there's a completely different determination versus a reading of the record that says, first, he indicated that it was the entire door somewhat in an ambiguous way, but then clarified it by indicating that it was just the top track that came down.
Well, it's our position that he said it was the top track. He was asked to clarify.
On page 233, he's asked, so you didn't tell them that the top track shifted. Answer, the question, you didn't tell them that the top track came down on your right hand. Answer, I told them the whole door did. Everything was connected. It was all screwed together. I didn't build this door. I'm not sure how you can ignore that.
except that he's at 102, it says something shifted. And then he says, the whole top track came down on my hand.
Right, and then on the next page, he says, I told them the whole door did. Everything was connected. How can you choose to credit one and not the other? You've moved for summary judgment. We've got a record that none of us is sure what happened. How can we grant summary judgment given that?
Except that when he's questioned here, he's questioned about a vague statement that he made that something shifted. He clarifies that what he meant by something shifted was the whole track.
And on the next page, he clarifies, I told them the whole door did. So how can we grant summary judgment when there's inconsistencies in the document you're asking us to rely on, and you can't tell us what the version is that you think is sufficient on which to grant you summary judgment?
Let me just say, under either version, if it was the door or the top track, you're talking about a door that was already installed.
So what?
Well, under the circumstances, it would not be a situation where you would expect to have a safety device.
He was told to install a door buck on this door frame. So if what you're arguing now is that it was a permanent feature of the installation, then why would it be that he was then told by his supervisor under the direction of the general contractor to then install a door buck on it?
I just wanted to, the one thing I wanted to direct the court's attention to, it was the case we had cited in our brief.
But I don't understand your theory. Is your theory that it was a permanent structure?
Yes.
And why would he have been told to install a door buck on a structure that's permanent?
Okay, I wanted, the reason why I wanted to direct the court's attention to.
I'd like you to answer my question.
Yes, I wanted to direct the court's attention to this case, Marin versus AP Amsterdam. It's a situation where the plaintiff was working on the exterior of a building installing a drain pipe. And what fell was a portion of the drain pipe that he had already installed. And the court said in that situation, and this court has cited Marin in other cases too, the court said 240 doesn't apply because the drain pipe was already installed and became a part of the structure.
In this case, it hadn't already been fully installed because he was told to do work on it.
Right.
To install, okay.
Thank you. Thank you very much. 585 Gerard Acquisition versus GAL Manufacturing.
I was hoping for clarity.
Yes, you may proceed.
Good afternoon, Your Honors. My name is Joseph Noonan from Rosen Law LLC. We represent the plaintiff appellant in this action. In short, we're here today because the lower court dismissed the complaint completely and all the allegations asserted within with prejudice. And this basis was found upon documentary evidence that was submitted by the defendant's respondents. The documentary evidence that was submitted by the defendant's respondents, however, was only the purchase and sale agreement as well as the amendments to the purchase and sale agreement. However, our claims...
Wasn't that a sufficient basis to grant the motion pursuant to 3211A1?
It's our position that it's not, because our claims were based on fraud as well as breach of contract, as well as breach of the covenant of good faith and...
Well, let's just first deal with the breach of contract claims.
Okay, so as far as for the breach of contract claim, one of our positions is that the idea that one party could terminate a contract for any unfettered discretion.
But you agreed to that. Provided for that.
But what our position is that clause is not an enforceable clause.
I don't understand. In both the 19th and 20th Amendment, you agreed to a provision that said, the 19th you said only one side could terminate it. 19th and the 20th you said either side could terminate it at least 2 days before the closing date. Why isn't that enforceable if you agreed to it?
Our position that contract clause cannot be enforceable because it removes the idea of consideration and conflicts with other potential, and not even potential.
So these are not, but these are sophisticated parties who negotiated this agreement and then amended it 20 times. And you're saying that we should say that we can't enforce a provision agreed to by these two very sophisticated parties, or 4 sophisticated parties, I guess?
Your Honor, that is one position of why the breach of contract has happened. The reason that we're saying is it's unenforceable because that provision removes consideration and allows for an individual
Well,
to
we understand
terminate.
your argument, but what we don't understand is why you would not be bound by a provision that you agreed to.
Well,
That you contracted for.
because there are numerous examples of contracts in which people enter into that have clauses that cannot be enforced. And one of the reasons why we believe that this can't be enforced is because it would allow an individual to breach the contract in bad faith. Because
That would be one, I'm sorry, go ahead.
But it gave the right to both parties. So it's not as though the right was only given to one party to leave the contract.
and I believe that may be the position from the other side, but our position is that it removes the consideration. And now the other reason for the breach of contract claim, why we believe it should survive.
What case law do you ask us to rely on that an agreement that is negotiated by two sophisticated parties that says either of them can get out of the contract anytime they wanted is unenforceable? Do you have any case law that supports that?
Well, what we have is we have certain case laws that said, and as which was cited, in which if it removes, if the contract removes a party's right to receive the fruits of the contract, which is 511 West 232nd Street Owners Corp. Versus Jennifer Realty Co., we're saying is that if you remove the idea of good faith from a contract, but even if it's either side, what it's saying is that we're saying that there is then a lack of consideration, which makes our position that that clause is not enforceable. Now, the next aspect of the breach of contract has to come with the letter of intent. Now, what the other side has argued and what the lower court determined as far as oral modifications is they said that the oral modifications were not enforceable, but we're trying to allege...
Who signed the letter of intent?
The letter of intent, I don't have a record that it was signed by both sides, but it would constitute as a partial written agreement between the parties.
When you say not signed by both sides, it was only signed by you.
But it would qualify as a partial written agreement that explains a contract modification, which then had and was a part of the part performance of our client. Underlying this case is that our client was going to build what was going to be a new stadium. We acted in good faith throughout the entire time, and then when the 20th Amendment happened, we entered into the 20th Amendment in good faith. The other side, 2 days after, in a sense, forced our client to basically pledge an additional $25 million for that same property. And in doing so, our clients within 2 days managed to secure those funds to enforce this new $25 million increase. They then took that offer of $100 million to shop around to other individuals at an inflated price to then sell the LLCs that owned the real property to defendant OTPP, which is the basis of our fraud claim. And what the lower court determined and dismissed the causes of action for fraud on the basis of, one, determining the credibility of the claim, which is in violation of Leo versus Mount St.
Is it
Michael.
duplicative of the breach of contract claim?
That was the other one, it was duplicative, but the fraud claim is separate from the breach of contract. Breach of contract is that they never closed at the closing date because that termination was unenforceable. The fraud claim has to do with this idea that they basically got our clients to come up with an additional pledge of $25 million and then use that to shop around so another party could purchase that and then own it out from underneath our clients, which is why we don't believe...
The continuation of that is that not go through with the contract.
Pardon?
The continuation of that sentence is that the result would be that they wouldn't go through with the contract, which is the breach of contract claim.
The continuation of the sentence would be that because they sold it... No, because what we're trying to say is that the fraud has to do with the deception to increase that there was never an intent to actually sell the property at that point when the 20th Amendment was put in. The intent was to inflate the property value so then they could sell $500 million worth of shares to defendant OTPP and actually have that properly valued, which is why we've also claimed for unjust enrichment and quantum merit, because our letter of intent has essentially given an extra $25 million in value to defendant OTTP and defendants Golden Gate Capital.
Thank you. You have time on rebuttal.
Good afternoon, Your Honors. Richard Slack from Weil, Gotchel, and Manges for the defendants, respondents, the GAL respondents, as well as the Ontario Teachers Pension Plan.
Counsel, I do have a question about that letter of intent. That was sent to the party that ultimately purchased this property, right?
The only thing that's in the record is that it was sent to the company and to Golden Gate, who owned the property at the time.
It wasn't transmitted to OTPP?
It certainly wasn't transmitted to OTPP at the time. There is in the record at 627 the letter of intent with the email, and that email does not go to OTPP. It goes to GAL and Golden Gate, the representatives. It does not go to OTPP in terms of what's in the record. So, Your Honor, the appeal here doesn't raise any cutting-edge issues. Instead, what it does is it asks the court below, and now this court to affirm, based on the well-established policy of the New York courts, that when the parties set down their agreement in writing, that agreement's going to be enforced. And here, of course, you had sophisticated parties in a real estate transaction, and I think as some of the questions that we had before show, the parties here not only agreed to a termination provision, that was reaffirmed 20 times, including in the 20th Amendment. And what's important about the 20th Amendment is the 20th Amendment actually goes not just to the contract claim, but to every claim here, because the conversation, there's really one set of conversations that embodies both the breach of contract claim, but also the fraud and all the other claims. And it all arises out of the same conversation. And that conversation in the record took place on July 21st. But on July 26th, the 20th Amendment was entered into, and that reaffirmed the termination right. So the idea that you had, whether it's the breach of contract or some kind of fraud claim where the parties, where supposedly it was, you give me an offer and agree not to terminate. 5 days later, from this agreement, supposedly, the parties negotiated, executed, and signed an amendment which expressly granted and preserved the right to terminate. And so what the court below found with respect to essentially all the claims is that all the claims are embodied in that same conversation and arise out of the contract, and applied the well-established law here that you can't sort of turn a breach of contract into a fraud claim. And at the same time said there's no way that the plaintiff here could have relied on some kind of promise not to terminate as a matter of fraud, because 5 days later, they entered into the 20th Amendment, which specifically preserved it.
I thought the argument was that the fraud was that that the price was inflated, and that it was intentionally inflated so that, and then to shop it to other prospective buyers.
Well, so let's look at, take all the dressings out, Your Honor. What happened here was that there was an offer that was made. The question was, put your offer in writing. And so they did a letter of intent. The letter of intent, again, which is at 627 in the record, specifically says that it's non-binding. So all that happened here is that the appellant gave to GAL and Golden Gate a letter of intent that was unsigned, non-binding, and the argument is that some...
Letter of intent support a oral modification of the contract, or at least a partial oral modification of the contract with respect to the termination provision?
Well, I would say no.
Why?
Chiefly because, again, even if there was this oral modification, right, you then have a letter of intent. It says exactly opposite, right? Because what it does is it says that nothing in the letter of intent says it's getting rid of the termination right or the no oral modification rule. To the contrary, it says this isn't binding until there's a written agreement. So there's an understanding that you can't modify the agreement until you have a writing, and that's embodied in the letter of intent. The other thing, Your Honor, as I said, the 20th Amendment came after it. So even if there was this oral agreement that occurred on July 21st, which there isn't, the July 20th Amendment, which preserves the right to terminate, supersedes that under the law. So one other point, Your Honor, that I'd like to make, which the appellant had said that one of the reasons that there's no breach of contract is that there is the clause itself is unenforceable, and I think there were some questions. And what I would suggest, Your Honor, is two things that are important. They make that argument in the reply brief. It's the first time they make the argument that these clauses are unenforceable, and so this court can disregard those arguments in any event. But I would say, more importantly, there's nothing in the law and no case cited which suggests that parties can't agree to an at-will termination. And I would point out that there are numerous cases, and for example, the transit funding case that Justice Gessmer was involved in specifically said that, quote, where a contract allows one party to terminate the contract in its sole discretion and for any reason whatsoever, the covenant of good faith and fair dealing cannot serve to negate that provision, showing that you can, in fact, have those exact kinds of clauses. Thank you very much.
Thank you. Here.
Good afternoon, Your Honors. Greg Laufer for Respondent Golden Gate. I just want to make one overarching point. This is a real estate deal gone bad. Somehow the plaintiff has managed to concoct 16 separate causes of action when there was a contract between it and one of the parties. If somebody is wronged, you're not wronged to the tune of 16 different separate causes of action when all you're talking about is a real estate deal. And
What about this letter of intent that the plaintiff asserts that was sent around to inflate to show proof of price inflation so that you guys can get a better deal from someone else?
Sure. There are some, again, we're assuming that the facts as alleged are true. The problem with that theory is at least twofold. One, they would still have to prove justifiable or reasonable and actual reliance. They can't, because they didn't actually do anything. All they did was say, here's a piece of paper, by the way, we're willing to give you $25 million more. That's not reliance, and they couldn't actually rely because the no oral modification clause in the underlying agreement, which Golden Gate wasn't even a party to, precludes them from relying on any supposed oral promise. And in any event, there was all this discussion, I think this actually addresses your question as well, about quantum merit and unjust enrichment and all these other claims. The appellate didn't actually get impoverished by any of this. My client, a private equity firm, had funds that had an ownership interest in the portfolio company that owned this real estate, and we ultimately sold our interest to a third party, which is the Ontario Pension Fund. The appellant is not actually out of pocket one dime for any of that. It has nothing to do with them. They didn't have to give anything else, and in fact, if anything, they kept all their money. So I really am not sure what they're complaining about. With respect to the contract claim, I don't think that they actually dispute that no oral modification clause actually bars them from showing reliance. They've thrown up all these issues in an effort to circumvent that clause. They've said that lawyer affirmations, on the one hand, can't be used because we don't have personal knowledge of the facts. Lawyers put in affirmations attaching documents all the time, and in any event, all of the documents that we're relying on, the contract, the side letter, and the amendments were all incorporated by reference into the complaint, and they don't dispute their authenticity. Then, paradoxically, they say, well, on the other hand, you don't have any affirmations with facts. This was a motion to dismiss under 3211. We don't have to put in facts. We're supposed to take the facts as alleged to be true. And then finally, they say that the contract and the other amendments that we put in that they incorporated into their complaint don't actually refute their allegations. That is inaccurate. They do just that because they said, thou shalt not rely on oral modifications of the contract, and it's very clear. I want to go back to something that both of my colleagues said a few moments ago about the enforceability of the no termination clause. I am not a transactional lawyer. I'm a litigator, but I do plenty of work with my transactional lawyers, and I litigate termination clauses all the time. Parties put those in contracts all the time, and particularly where, as here, as Your Honor pointed out, they have done so over and over and over the course of a couple of years. it's kind of hard to understand where they're coming up with this, as my other colleague pointed out, totally newly minted argument that appeared for the first time in a reply brief on appeal. And on top of that, there was a suggestion by the appellant that this somehow vitiates the implied covenant or reads good faith out of the contract. That's inaccurate. It doesn't say anything of the sort. Even an unfettered discretionary right in a contract has to be exercised in good faith. That is New York law, and the contract does not suggest otherwise. Very briefly, on the non-contract claims, there are, I think, 8 or 9 of them, depending on how you count, asserted against Golden Gate. They all fail for the reasons that the motion court cited. They are either duplicative of or subsumed by the contract claim, and or they are precluded because there can be no viable allegation of reliance. And the appellant's brief on appeal does not actually address any of those arguments. It does not cite any contrary case law. And so for all these reasons, we're asking the court to affirm the decision below with respect to Golden Gate.
Thank you.
Thank you.
Your Honors, I would like to just make a couple of points just about specifically the idea that we don't make any contention with the lower court's determination of reliance. One of the necessary elements for fraud is justifiable reliance. When we say that the lower court erred in finding that there was that we did not properly state a claim for fraud, that is also encompassed by saying that the lower court's determination that we did not justifiably denied was improper and wrong and incorrect. And that's why what they are trying to now say is that we have left that argument out of the record. However, it is encompassed in multiple sections of our initial brief and then further detailed in our reply brief. One topic that I would like to also just get out there was this idea of, and we briefed this and which has not been addressed yet, is this idea of credibility. The lower court made a determination of credibility on behalf of our causes of action.
I don't understand that argument. Didn't the lower court just look at the contracts, specifically look at the 20th Amendment, and made a determination of what the agreement said, giving both parties the right, the unfettered right, to terminate by February 8, 2015?
What the lower court did when they issued their opinion is the lower court made determinations of our allegations, and as quoted by the lower court, were simply not credible. As stated in the longstanding law, credibility of a plaintiff's allegations are not a determination on a 3211 action. So the fact that the lower court made a determination of credibility is in violation of Leo versus Mount St. Michael, which says that you're not allowed to make determinations of credibility on a motion to dismiss.
I read that, and I don't think that the trial court may have misspoken in a sense. I think what they meant was it's not legally recognizable, and I don't see that that's not true.
By making,
I mean, especially because, for example, and I asked you earlier about whether or not you could knock out an agreement between two sophisticated parties, and you cited the Jennifer Realty case, which was a case involving two unequal parties, a sponsor and a tenant, in which the court specifically said these are unequal parties, but that has nothing to do with your case.
Well, the issue that we have with the determination of credibility was with the fraud allegation. And the fact that the court determined that our allegations of fraud were not credible and the causes of action deriving in fraud were not credible, it's our position that...
Let me just say that what the court said in terms of your letter of intent, it said it is simply not credible that the only reason for the 2018 agreement was to increase the purchase price of an asset to be purchased by an unrelated entity more than 3 years later.
And that is, yes, and that is...
So again, it appears to be, as my colleague stated, not that credibility in terms of assessing whether you're telling the truth or not telling the truth, et cetera, but credible based upon the allegation.
Yes, but
a credible statement.
But our position is that determination of credibility were the facts of the fraud. So by the court making the determination that that was simply not credible is the court's determination.
What went on to say it's negated by the no oral modification, et cetera.
But it is our position that the lower court at a 3211 motion to dismiss should not have dismissed this with prejudice, nor that the documentary evidence provided utterly refuted all of the allegations. And that is what encompasses why we are here, is because the lower court should not have dismissed everything based on the contracts and should have permitted the case to move forward, at least to discovery.
Thank you. Madam Kalin? Yes, please proceed.
Good afternoon, Your Honors. May it please the Court. Sean Egan for the Bronx Defenders for Juan P. Your Honors, families are different, and each action of a family member needs to be.
I do not believe that the allegations stated here would be acceptable in any family dynamic. So, continue.
Your Honor, may I just have one moment?
Sure.
In this case, context is everything. It's important to look at three different factors in this case to assess that Mr. P's intent in this case was not for the purposes of sexual gratification.
The trial court made a determination of credibility, and we're bound by that unless there's something terribly wrong with it. And the trial court's determination was that the child was far more credible than the grandfather.
Unlike the previous case where we're talking about credibility in the context of the arguments, we're talking about the credibility in the context of the statements made by the child.
Yes, and I do think, Your Honors, it's important to look at the statements of Kaylin because I think those statements are the ones that provide the context that show that the acts in this case were not acts intended to harm this child, but acts that were from a albeit misguided and inappropriate joke. The testimony of Kaylin.
I think we should really stop and just take a step back, counsel, and just think about what you're stating. There's no joke here, okay? It's not a joke. It wasn't a joke. The conduct alleged here can in no way be seen as a joke, okay? So why don't we focus then on the statute and focus then on whether or not the actions alleged comport with the statute and whether or not we should abide by the determination of the court in terms of credibility. Let's try that.
Yes, Your Honor. So the statute requires 1012 or 1012E requires us to look at the CPL to find out whether Mr. P had the requisite intent that these acts were for the purpose.
And the intent be inferred by the conduct itself.
And in this case, just to supplement, the multiple serial acts of touching of the intimate parts of a child's body.
So I'll take both of those. So the first intent can be inferred from acts themselves. But as the court noted as the Court of Appeals noted in Hatton, there are factors that can help determine whether or not that we should look just to the acts themselves. Acts between family members and between strangers are different, and the court has acknowledged that in the matter of AG, where we see that the acts between a family member and a child may not automatically give rise to the same inference. And I think if we look at the context here and we look at the testimony, it suggests that these were misguided attempts to display affection and not for the purposes of sexual gratification.
That's your position. The question is can intent be can intent be inferred based on what occurred here? The child, I think, was from the age of 13 onwards. For years and years and years, there was inappropriate touching of the child.
So intent can sometimes be inferred from the acts themselves, but I think...
What about the fact that there were requests for this conduct to stop, but it continued? Can we then now infer even more?
I think in this context, what it suggests is that Mr. P just didn't get it.
What context?
In the context of a family that regularly joked about butts and bodies in the family.
Is there anything in the record that this individual, this grandfather, joked, quote unquote, joked with anyone else in the family that he wanted to take a shower with them, or in any other member of the family that he smacked them on their buttocks or made comments concerning their bodies?
No, there is no...
Thank you. You have time on rebuttal.
Good afternoon, Your Honors. May it please the Court, Lauren O'Brien on behalf of Respondent ACS. The appellant's attempt to offer an innocent explanation for the conduct here is simply not supported by the record. First, as Your Honors noted, it can't be squared with the granddaughter's testimony, which the family court expressly relied upon and credited. And here I'll just note we have a child who was, at the time she was testifying, 17 years old, testifying about conduct that occurred from the time she was 13 to the time she was 17. She was very capable of discerning at that point what was playfulness and what was inappropriate conduct. And she did repeatedly testify that she asked the appellant to stop, and he continued engaging in this conduct after she asked him to stop. Second, for the most part, appellant's theory relies upon his own testimony, which, again, the family court found incredible and self-serving. And here, as your honors know, the family court's credibility determinations are entitled to particular deference, given the context. Usually, all we have is testimony from the two parties involved. There's no external evidence or other witnesses. Third, even if this court were to rely on appellant's testimony, even his testimony doesn't support his theory. He talks about mere jokes, not about any touching. That was part of this custom of joking that he describes on appeal. And it's also difficult to square his theory with his denials of some of the more serious conduct in his testimony. And finally, appellant relies heavily on cases like Inri AG and Michael M. that talk about some differences between this general relationships and the special relationship between a parent and a child. That context is very different from the context here, where these are two more distant non-biological relatives, and where the conduct got increasingly worse as the child got older. Unless your honors have any questions, we ask this court to affirm.
Thank you.
May it please the court, the Legal Aid Society by Hannah Kaplan for the subject child. I would join in the arguments of ACS in this case and note that the blanket denials made by the appellant in his testimony at the trial court do not support the argument that his alleged joking justify his repeated touching of my teenage female client's buttocks over years. She was very clear in her testimony, which was fully credited by the court, that touching was unwanted, and she spoke those words. She told, not only would it be inappropriate in any circumstance, but she explicitly told appellant to stop, and he continued. So the appellant's argument that he misunderstood a teenage girl repeatedly telling him no it just can't find support in the case law or the record before it. The appellant also doesn't...
Or common sense.
Or common sense. And the appellant did not go into trial court and say, I'm so sorry, Your Honor, I made this mistake, I misunderstood. That's appellant's counsel's argument. Instead, the appellant just denied that it ever happened, saying at most maybe she misunderstood the way that we played. And the family court rightly rejected that argument.
Thank you.
So I just want to touch briefly on the conversation about the theory of reliance on Mr. P's testimony. So Mr. P's testimony was clear that he did not recall touching his granddaughter that way, but he would not do that. And maybe she misunderstood the way they were playing. Now, Kaylin was very clear. She was uncomfortable. This was inappropriate behavior.
But the trial court heard that testimony and credited her testimony over his. Why would we not defer to that?
So I think the important parts to look at in her testimony are when she describes this interaction to be in a joking manner, that he was a playful person, that he was playing with her. They were playing with their hands.
Was he joking when he invited her to have a shower with him?
The testimony from Kaylin is that he was joking with her, that he was pulling on her arm like it was a joke, and that he was joking and they were playing with their hands like they played before, right?
But she requested that he stop. She requested that he stop joking. She requested that he stop making these jokes.
I understand that she said she requested she stop. There's also testimony that she didn't have a heart-to-heart conversation with them or a talk-talk, suggesting that...
A what?
A talk-talk.
A talk-talk.
Yes.
What is that?
So
It's, I'm sorry, she said that, I didn't see that in the record, that's why I was asking. She Yes. said a talk? yes. Okay, that was- and the significance of that is what? So included in that testimony, she says that she laughed it off and he was laughing it off. I am not saying that these are appropriate actions. I'm not saying that he shouldn't have stopped. What I'm saying is that based on How old that, is your client? How old was he at the time? I believe in his early 60s. Early? 60s, I believe. Thank you all. Your mommy laughs versus harassment of an advanced age. The advanced age.
Good afternoon, Your Honors. Joseph Drews on behalf of Appellant and Defendant Alexander Golubitsky. Your Honors, in the case below, my client raised a motion to dismiss, and as we know, under 3211E, you get to raise one filing. Accordingly, the motion raised an anti-SLAPP under
Why was the case dismissed against your client?
for under A8 for
Lack of jurisdiction?
lack of personal jurisdiction.
Personal jurisdiction. Okay. Then how, under those circumstances, if the court agrees with your client's position that there's no personal jurisdiction over your client, how does then the court go on to analyze statute and grant your client affirmative relief?
Say that last part, Your Honor.
How, in those circumstances, can the court, when it has no jurisdiction over your client, personal jurisdiction, grant your client affirmative relief?
Well, Your Honors, I believe that this court noted under Reeves that once an anti-SLAPP motion under A7 is
Are you acknowledging jurisdiction then?
No, Your Honors.
In Reeves, however, there was a finding of a substantial basis, right? Because you're not just entitled to attorney's fees just upon success. It's upon success of a finding of no substantial basis to bring the action. And if your case is dismissed for lack of personal jurisdiction, that issue obviously isn't decided. It doesn't need to be.
Yeah, yes, Your Honor, but I believe under the recent 2020 amendments that once a anti-SLAPP motion is brought, the court has to address the anti-SLAPP motion in the first instance, and if that motion is granted, then go on to the mandatory attorney's fees.
Except for if your client claims that there's no jurisdiction to address that.
No, Your Honor, and I want to draw the distinction between subject matter jurisdiction and personal jurisdiction. Subject matter jurisdiction means a court can address the case.
How do we get to subject matter if we don't have personal jurisdiction?
We can't even talk about the thing if we don't have any jurisdiction over the actual person
We don't,
there.
exactly. I don't understand. If we don't have personal jurisdiction, how do we even get to subject matter jurisdiction?
Because subject matter jurisdiction goes to the heart of the court's ability to address the case, whereas personal jurisdiction, which is waivable, just talks about whether—
Are you waiving it? Is your client waiving personal jurisdiction?
No, Your Honor.
If he's not waiving it, then how do we seem to be going in circles, but we can't get to subject matter jurisdiction if we don't have personal jurisdiction over the person. Your client chose to assert that to fight the case. That's his right. But then how can he now come in and turn around and say, oh, I don't want to be a subject of this case, but I want to assert my own claim? Once he starts doing that, he's accepting personal jurisdiction. He's asserting that the court has personal jurisdiction over him. You can't have it both ways.
I have to push back on that, Your Honor, because my client's rights to assert, for example, an anti-SLAPP defense—
Okay, so today is a day of semantics. Partially healed, completely healed, personal jurisdiction. What in your argument, what do you assert is the definition of personal jurisdiction?
The definition of personal jurisdiction is whether under the state long-arm statute, in concordance with due process, a court can hail a defendant into court.
Thank you. Okay, so your argument is we cannot do so. We cannot haul your client into court. Is that correct?
Correct.
Because you are not subject to this jurisdiction.
Under the long-arm statute.
Under the laws of this jurisdiction. Is that correct?
Correct, Your Honor.
Okay. Therefore, how do we get to subject matter jurisdiction?
The point I'm trying to make, Your Honor, is that my client's rights are cumulative and not in the alternative. The legislature provided a robust—
And not in the alternative.
Yes, Your Honor. my client's rights under the anti-SLAPP statute, which need to be teed up.
If we do not, again, as my colleague said, we're going around in circles. If we don't have jurisdiction over the person, I don't see how your client therefore would be able to assert any claims under the laws of this jurisdiction. But you do have time on rebuttal, I believe.
Good afternoon, Your Honors. May I please the court? Evgenia Vetrenko for Appellant Umami Labs. Once the trial court granted appellant's motion to dismiss for lack of personal jurisdiction pursuant to CPLR 3211A8, it correctly declined to address additional grounds for dismissal, such as for failure to state a claim. And the trial court's decision was correct and should be affirmed. It is a fundamental principle and long-standing precedent in this court that before a case can reach the merits of the claims, it must be established that the court has personal jurisdiction over the parties. And this is also why any defense based on lack of personal jurisdiction has to be asserted in the defendant's first move before the court, whether it's pre-answer motion to dismiss or an answer. And a failure to raise the lack of personal jurisdiction would result in a waiver of the same. So here we have the logically correct decision of the court to.
Does your adversary is arguing essentially that the amendments to the anti-SLAPP statute actually now the court's required, I guess, to actually go through the analysis to make a determination whether or not attorney's fees are called for. Does the statute make any difference here?
So it doesn't make any difference in this case because the statute allows the party to bring the anti-SLAPP motion to dismiss at any point in the case. And so at that, it addresses the ability to, for the court to address that motion ahead of any other motions, ahead of any discovery, ahead of having any hearings when it's brought at any other point in the case, when the case is already in front of the court. When the court's first inquiry is into personal jurisdiction, the court is deciding whether it has to go and address the case on the merits. And as this court said in Reeves, the determination for under anti-SLAPP is a decision on the merits. So before the court can get to the merits, before it can get to subject matter jurisdiction, it does have to decide that it has affirmative jurisdiction over all of the parties, and that only then can it address other grounds.
Thank you.
Your Honors, I would submit with the recent amendments, once a motion, an anti-SLAPP motion is brought under A7, that the summary dismissal procedures kick in, and that the legislature has statutorily determined the sequence of events.
But counsel, once you ask the court for affirmative relief, aren't you acknowledging the court's authority over your client? Because your client is asking the court to do something for him. The court can only do that if the court accepts jurisdiction over him personally.
I would submit this distinction, Your Honor. When a litigant, an anti-SLAPP defendant, raises an A7 anti-SLAPP
So
motion,
the personal jurisdiction rules that we apply and everything else don't apply under the anti-SLAPP laws?
I would submit that given the recent statutory changes and the interlocking statutory scheme, that the trial court.
Anything in the statute that says that we should throw out all of jurisdiction law for the sake of this statute?
Right. I mean, that's what you're saying, is that jurisdictional law in terms of personal jurisdiction, et cetera, would just be, it's null and void based upon a statute.
Well, I would submit, Your Honors, under 3211G, the recent amendments, subparagraphs or subpoints 2 through 4 require the court to go through that analysis and then provide the relief against the anti-SLAPP plaintiff in favor of the anti-SLAPP defendant.
In other words, you get it both ways.
Yes.
You
Yes, and I'm not trying to hide the ball on that, but I believe that is consistent with the legislature's purpose of an anti-SLAPP statute.
But if the legislature was doing something so radical, wouldn't they have to say that somewhere?
I believe they said it by putting in subsection G that talks about the automatic stay and then the resolution of the anti-SLAPP motion and the concurrent or.
Well, that would be interesting. Is there anything in the legislative history that says that that was the intent of this legislation, was to provide that any litigant could avail themselves of the statute regardless of whether they stated that there was personal jurisdiction or not?
I would submit, Your Honors, in the Reeves decision, it went through the legislative history, and it talks about the expansion of the anti-SLAPP provisions. And when it comes down to it, Your Honors, I think I put it this way. When a defendant has to defend on anti-SLAPP grounds, what is the biggest thing that the defendant is worried about? Attorney's fees. And what is the one thing that will deter an anti-SLAPP plaintiff from abusing the process? It's the possibility that that anti-SLAPP plaintiff is going to get tagged with attorney's fees.
So all rules, regulations, statutes, et cetera, are just thrown out the window based upon that.
I would submit, Your Honor, that would be consistent with what the legislature envisioned and the recent
That's not
amendments.
even consistent with the language of the statute that refers to this substantial basis, like there being no substantial basis. That's a finding on some kind of merit.
It's the merits of what is pled, because this is teed up in the context of an 87 motion to dismiss.
Thank you. People v. Sean Pessoa. Oh, red light's on. Sorry about that.
Good afternoon, and may it please the court. I'm Jihyun Rim with the Legal Aid Society on behalf of appellant Mr. Sean Pessoa. Mr. Pessoa is burdened with an 8-year order of protection following a physical altercation with the complainant. Mr. Pessoa was the passenger on the complainant's taxi. CPL 530.13 mandates courts to state on the record the issues for issuing or not issuing a final order of protection.
Was there a temporary order of protection?
Yes, Your Honor.
And the temporary order of protection informed your client as to what the terms and conditions of the order of protection were and the basis for the order of protection?
Yes, a temporary order of protection was issued against the
And so the defendant was already aware of that there was a temporary order of protection and what his conduct was and how it modified his conduct. Is that correct?
The language of the statute is mandatory. CPL 530.13 does not make an exception that allows this court to glean reasons from the order of protection itself. It has to be stated on the record the reasons for issuing or not issuing a final order of protection.
And this argument was made before the trial court?
No, Your Honor, it was not.
So it's not preserved?
It's not preserved, but in Nieves, the Court of Appeals has found that this court is able to review it based on its interest of justice powers. Your Honors, the Court of Appeals has acknowledged in Nieves that an order of protection is designed to protect a victim or a complainant, and this is really important when there's an ongoing relationship. There is some sort of heightened risk to that individual.
If we agreed with you, what would be the appropriate remedy?
The appropriate remedy would be full dismissal in this case, Your
Would
Honor.
it not be to remand the case back to the trial court? for them
Right, to
determine
remand it
that
back to the
issue?
trial court so the trial court could state on the record that there is a permanent order of protection issued and that the defendant is not to have any contact with the complainant?
Certainly, Your Honors, this court can remand this, but what Mr. Pessoa didn't request remand in this case because it's already been 6 years at this point, and the purpose is.
And has there been any contact, or that might be outside of the record?
That's sort of outside the record, but
Right.
as far as we can infer from the record, he's made no contact. And
So I'm sorry. So you're stating that the remedy you're seeking is to vacate the order of protection?
that's correct, Your Honor, because this was clearly a one-time event between two strangers. Mr. Pessoa has made no contact with this.
The order of protection has already expired, right?
No, the order of protection is set to expire in 2026, so there's 2 years left, Your Honor. And so the order, if there was a purpose to this sort of invalid order of protection, it's already been served at this point. He's 6 years in, and he's being burdened by this order of protection that was improperly issued in the.
If he doesn't, I mean, you say he doesn't know the other person, so how is he burdened by it? I don't get it.
There's always the risk of further criminal liability when there's an order of protection against.
It's been
Your
6
Honor.
years.
It's been 6 years. Yes, that's correct.
And there hasn't been any contact, any violation of the order of protection?
No, Your Honor, not from the record.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Noah J. Sexton for the people. As contained in our brief, we believe that there are at least 3 bars to review of defendant's claim.
The one is preservation, is that correct?
Preservation, I believe, is really the main bar to review of defendant's claim. He at no point attempted to challenge the order of protection, point out any issues with the court's treatment of it, and he had ample opportunity to do so, considering that the order of protection was a stated part of this negotiated plea. And while this court is empowered to exercise interest of justice jurisdiction, there's no real reason to do it in this case. There's no extraordinary burden being placed on him beyond what's placed on any other defendant who commits a violent crime and a final order is issued. As much as this is a terrible crime, it's not a particularly unique case in its circumstances.
But what further purpose does the order of protection actually serve? I mean, it's 6 years in, there has not been any contact that we're aware of, and that there has not been any violations of the order of protection. So again, they're strangers. Why not just vacate the order of protection?
I mean, I think the interest that it serves ultimately is to make sure that this complainant who was willing to work with us and was willing to speak about what happened to him continues to be protected. I would note that there isn't really anything on the record that would indicate they've had no contact. There's been, no contempt charges related to the underlying order, but, they interacted with one another at least twice on these two separate occasions, and we don't know if that has happened again. If this court does agree with defendant that this is a defective order anyway, it should be remanded as opposed to just outright vacated so that the issuing court can correct these errors, perhaps consider these arguments that it's been 6 years and, maybe it should just go away. But at this juncture, on the appellate level, it's not enough information in front of us to say outright vacature is fine. I would also briefly point out that the duration argument the defendant makes, the duration was clearly indicated on the order of protection. Order of protection indicates that he was informed about the contents of the order and the effect of the order. He didn't sign it because he was wearing safety mittens, not 100% sure what they are, but he was not able to sign them.
You don't know what safety mittens are?
There were safety mittens on, yeah.
You don't know what they are?
I mean, I kind of assume they're mittens that keep people safe, but they were on.
Wow. Wow.
Yeah.
No, not quite.
Not
but
quite.
Okay,
Yeah.
go ahead. I'm
yeah.
sorry. Go ahead. That's your homework, is to speak to other assistants in the office and find out what the mittens are about.
All right.
Okay?
Absolutely.
Thank you.
Yep. Unless the court has any further questions, we ask you affirm.
Thank you.
Just briefly on some of the things that my adversary has stated. We have to care about this because Mr. Postoa's rights were violated when the trial court failed to state the reasons on record as mandated by statute. We talk about little risk, but that's why we have to care.
So if counsel, if we did not agree with you in terms of vacating the order of protection, would you be opposed to remand for purposes of a statement on the record by the judge as to the order of protection?
I'd have to talk to my client first, and then I will get back to the court regarding that. I also want to emphasize again, the language of statute is mandatory. The CPL does not make an exception that allows this court to glean reasons from the record and the order of protection itself. I'd also like to state for the ADA has mentioned that they've met twice. There's nothing in the record that indicates that they had any sort of relationship. The complainant did not say that they had any relationship. There's thousands of taxis in New York City. To the extent that they've interacted before, the record only suggests that this was a coincidence.
I guess you could take an Uber. Thank you.
Thank you.
Milgrew versus the Board of Ed.
Good afternoon. May it please the court, Dina Kolker, Steptoe LLP for petitioners' appellants. This case asks the court below and asks the court to look at publicly available documents by respondent, Department of Education, setting forth statutorily required information in connection with a change in school
Counsel,
utilization.
why shouldn't you be required to exhaust administrative remedies before going to court?
For several reasons. One is that the questions asked of the court in this case are issues of pure statutory interpretation that are not required to be exhausted below with the commissioner. The commissioner and the DOE, and it's laid out in the papers.
Are you challenging the formula used, for example, the formula used by DOE with respect to capacity estimates? Do you make claims that DOE used factually incorrect data and incorrect assumptions? Isn't that the underpinning of your?
The explanation about the blue book and the utilization and the footprint and what's contained in it and what it tells us is in there to explain what it doesn't tell us, which is class size. There's a lot of facts in there to provide context to the claim, but the claim is actually straightforward. The law requires that the EISs discuss the, quote, impact on students. They do not categorically discuss class size, provide either information or the DOE's analysis of class size, certainly not an analysis of whether or not the proposed change in utilization will affect the ability to comply with the new class size law. And these other things that are included in the EIS are simply not a substitute for class size. That's all that is provided, and it is not the same thing as class size. So while we may have issues with the utility of that information, the import for this case and the argument to the court is not that the court should prescribe some formula, some footprint, or do away with the blue book, but merely that it is not class size. And class size is encompassed in the statutory requirement to discuss impact. And I don't know, several hundred pages of briefing, a lot of judicial time, a lot of attorney time, and it seems that the class sizes, actual class sizes in these schools that parents and educators and community members could understand is a state secret. We still don't know what they are. We still don't know DOE's view of whether class sizes will be impacted because they haven't told us. I would love to disagree with their substantive analysis of it, but they haven't told us, and that's the import of the case.
Counsel, you keep saying it's class size, but your petition specifically addresses a challenge to the determination to locate or co-locate a charter school, not class size, but that very determination.
The challenge is to the failure to adhere to the statutory EIS process that resulted in that determination. We do not ask the court to say whether the co-locations are ultimately wise or unwise or will negatively or positively affect the schools. What we say is you cannot make that determination unless you have satisfied the procedural and statutory requirements that allow disclosure.
What is the remedy that you're asking of us? I mean, aren't you essentially saying to us that we don't want these charter schools co-located in the public schools? Isn't that ultimately what you're asking for?
No, this particular determination is invalid because the process was invalid. But should they engage in a valid EIS process, where at the end of that process with the information, PEP, the Panel on Education Policy, votes to allow or continue these co-locations, then that would be a valid determination of the co-location. We are not asking the court.
You're asking us to invalidate the co-locations.
Yes.
So isn't that, under the education law, something really for the commissioner to do?
While I believe it's something that could have been brought to the commissioner, I don't believe it is something that is required. It is exactly the claim affirmed by this court in the first Mulgrew case, the 2010 decision, as we've been calling Mulgrew 1 in the papers, where the challenge was exactly the same. The EIS process was not adequately followed because the information disclosed, and the EIS process, like the secret process, is a right of information and disclosure. Boilerplate language that doesn't provide specific information about the actual schools being affected do not satisfy the statute and therefore invalidate the result, not because it is not wise and cannot validly be adopted at a later time, but because the process was not followed. And they had an opportunity when these issues were raised to amend the EISs in an attempt to correct the process, but they didn't do that either. The same is true on the safety topic. The regulations explicitly say that the EIS needs to talk about the impact on the safety and security plan of the school. What is?
Your time on rebuttal.
Yep.
May it please the court, Jeremy Schwader for the respondents. In Education Law 2853, the legislature set up a speedy administrative remedy for parties that want to challenge the determination to co-locate a school, and it was a process that's intended to avoid exactly what happened in this case. So what you have is 6 months before the co-location, the EIS has to be put out. 45 days later, there is, it's put out, sorry, there's a EIS. 45 days later, public hearing, then you have the vote on it. And what the statute sets up is an opportunity for parties to then go quickly to the Commissioner of Education if they want to challenge it. 10 days later, DOE has to respond. 10 days later, you have a decision from the commissioner. So if petitioners had used that process, which is required, they would have had a decision on this by December 2022. Instead, what they did was waited 4 months to almost the last day they could bring in Article 78, brought the Article 78, and then the litigation in that put all the schools in a situation where days before school started, nobody knew if the school could even begin. And that's exactly common sense reason why the statute exists, to prevent this. You need predictability for educators, you need predictability for parents. I want to talk a little bit about, this is the common sense reasoning. There's very, very strong statutory arguments as well, just basic statutory construction. Start with the statute. It says, the determination to locate or co-locate a charter school may be appealed to the commissioner. There is no way that they could use the word shall in that statute. May means shall here, but you can't write shall because you can't force anybody to appeal. If you wrote shall, you'd be saying you have to appeal. May means shall in this case because of the way the statute is done. And we know this because if you look later in the statute to section E3, where it's talking about charter school may have the option. They use very different language when they're talking about options. They say, shall have the option of appealing the decision of co-location either through arbitration or by going to the commissioner under 310 or by bringing in Article 78. So 2 different usages. One, you may use 310, which means you have to, because that's the only thing it says, and it wouldn't even make sense to reference 310 if that wasn't the one that had to be used. They're not writing this for no purpose. Later statute, it says you shall have the option. So what petitioners want to do is basically have us take all this optional language and put it into kind of write it into something that doesn't exist. That's not statutory interpretation. I know in their brief, petitioners say, well, don't worry about that later statute because the one we care about says, notwithstanding any provision to the contrary. I don't really understand that argument. We're not arguing that one provision overwrites the other. We're arguing they have to be read together, and this is the only way that you read them together. It makes sense. Mulgrew 2, I don't think the case law actually matters that much here. Both cases, Mulgrew 1 and Mulgrew 2, are good law. But Mulgrew 2, what it does, the key thing is it interprets the exact same language in the education law, and that's 211D, which still exists, where it says the determination of the trustees of the Board of Education may be appealed to the commissioner. And Mulgrew 2 says that means you have to exhaust first with the commissioner. And that's the exact same language we have here. So let me talk a little bit about the exception to exhaustion. I think that petitioners are finding a few cases from this court which have created an exception which has never appealed in any court of appeals decision, a 4th exception to exhaustion. I don't think that's really, the Court of Appeals has not gone that way. But even if there is such an exception, it would be an extremely narrow exception that would be only applying in the very rare situation where there are absolutely no disputed issues of fact. And what we have here is a petition that is 45 pages long, 162 paragraphs, 23 exhibits. It takes up 350 pages of the record. There is no way to look at this petition and say that it raises an issue of pure statutory interpretation. That it'd be very easy to write a petition that did that. And that is not what this petition is. You can start with the very first paragraph on page 10 of the record, and it talks about how the loss of science labs is something that they're taking issue with. And it just goes on from there. And I can go through paragraph after paragraph after paragraph of this petition. It is highly fact-intensive about these particular schools and the failure of this EIS and BUP to take into account situations specific to these very schools. So that is something that has to go to the commissioner in the first instance. I think if there's no further questions, I'll rest on our brief. Thank you.
Thank you.
The EIS is supposed to have information about these particular schools. Our problem with it is that it does not have information about these particular schools. And we set forth tables in our petition that say this exact boilerplate, generic, uninformative sentence is in these 15, 20, 30 EISs exactly the same, makes no variation for the specific circumstances of individual schools. That EISs have to account for that is exactly the holding of this court in the Mulgrew 1 case, where the court described the issue, which is exactly the claim made here, saying respondents mischaracterized the challenge, which is not to the ultimate decision with respect to the individual schools, but to respondents' alleged failure to follow statutory prerequisites in making those decisions. And one of the basic purposes of Article 78 proceedings is to determine whether an administrative determination was made in violation of lawful procedure. In that case, the EIS had said very helpful specific things like 200 seats will be lost, but there's other seats in the city. In this case, the EISs say things like specialized services in compliance with IEPs may be provided by schools anywhere, in hallways, in classrooms, in administrative rooms, in closets. These schools will provide them somewhere. That's not what the EIS law says. What the EIS law says is you have to talk about the impact on these schools of this proposed change, specifically with regard to specialized spaces. What the regulation says is you have to tell us what the impact on the safety and security plan is. All of our factual context is to point out that every single EIS just says every school in the city is required to have a safety security committee. This school will have one. They will deal with this later. That does not satisfy the EIS requirement that PEP, the community, the stakeholders have specific information about these schools in making this decision. The facts about the secure entrance and the metal detectors is merely to point out that that boilerplate language applies to every school in every EIS and nothing more when the schools are actually different.
Thank you. Hixby, City of Syracuse. Yes, you may proceed.
Good afternoon. May it please the court. Darian Balin on behalf of defendant appellants. The trial court here fundamentally erred in denying the City of Syracuse's motion to change venue when it applied CPLR 510-3, which was not a basis for the city's motion nor relied upon by plaintiff in their opposition. And frankly, the city didn't have to argue 510-3 because the city was asserting a statutory right to venue in
Is there no discretion under the statute? Does the trial court or does the motion court have no discretion under the statute?
There is some discretion, Your Honor. A plaintiff must show to overcome 504 that there are compelling countervailing
circumstances. And so plaintiff stated that in order to travel to Onondaga, that it would be a hardship because of his witness, treating physician, also his limited financial means, as well as the adverse effect it would have on his mental health, that it would be traumatic to some extent for him to have to return to Onondaga, where all of this took place, where he was, involuntarily transported from Harlem to Onondaga.
While he did assert some circumstances. The city's position is that those circumstances were not sufficiently compelling. The case law is clear that a plaintiff's individual circumstances are not to be considered unless that plaintiff is completely incapable of travel.
Well, he said it was a financial hardship. I don't know that that's what the case law says, but anyhow, he stated that that it would be a financial strain because of his limited financial means. I think he's on disability, if I'm not mistaken. Additionally, his mental health practitioner also stated that it would be a detriment to his mental health. So again, why is that not sufficient?
Because, Your Honor, if a generalized concern about someone's mental health was sufficient to present a compelling countervailing circumstance, then nearly every litigant who
No, but
suffers
it's a
from
little
mental health
different.
harm would be able to.
It's a little different in the circumstance. I mean, again, in the middle of the night, in the middle of winter, I think he's taken from Harlem, New York, and he's taken to Onondaga, and he's stating that he's in a holding cell. I forget for what period of time. He has psychiatric issues or mental health issues previously. This obviously exacerbated those. That condition. So again, I'm not understanding why, under the facts of this particular case, the court did not properly exercise its discretion. Also, there's no problem with the officers traveling to New York, right? Because they did it previously.
To arrest him.
To arrest him and haul him to Onondaga. So there's no inconvenience to them because they were able to do it in the past.
Your Honor, the city isn't required to show inconvenience to the individual officers. That's not a requirement under 504, which is explicitly to benefit municipal defendants.
The plaintiff can show compelling circumstances, which my colleagues are saying all of the things listed, the court in its discretion found them to be compelling circumstances. And why is that wrong?
Because the circumstances asserted by plaintiff were not sufficiently supported here. It was the unsworn letter of his doctor and his own self-serving testimony. We don't have any sworn proof about what her testimony would be, the specific effects on his mental health, or the sworn medical opinion of a doctor as to that. It's simply his own testimony and her unsworn letter, so they weren't sufficiently supported.
It's not a motion for summary judgment.
Change of venue.
The facts alleged still need to be supported, though.
Well,
You just have to be compelling.
It's supported by documentary evidence, which the court found compelling. And I guess for us, was that an improvident exercise of discretion? That's what we're grappling with, right?
And the city would submit that it was, Your Honor.
Great, thank you
Thank you.
so much. Enjoy your trip back to Onondaga.
Thank you.
How long is it?
Watch her leaving though. What makes you sure? See you later, man.